case is entitled In the Matter of the Marriage of Jenny Stevenson versus Kurt Zimmer, case number 17 DM 366. Would counsel announce appearances, please?
Your Honor, if it please the court, the petitioner Jenny Stevenson, formerly Zimmer, appears in person, and by and through her counsel, Christopher Vendeska, were both appearing by Zoom from different locations.
Douglas Kramer on behalf of the respondent, Kurt Zimmer. Both of us are appearing via Zoom video from different locations as well.
All right, we last appeared before the court on May 7th. At that time, the court ordered Mr. Zimmer to send financial information that was specified in an order filed May 21, 2026 with an exhibit ordering he provides 6 pieces of financial information. The court also ordered that he provide proof of medical condition to support his reason he's been alleging that no payments are being made on his obligations to Ms. Stevenson. So, Mr. Vendeska, we did set a status hearing. We were originally going to do that in July. It got moved to today. Mr. Vendeska, what's the status of the request the court ordered?
Thank you, Your Honor. Judge, and to answer your question, one other thing I would know, you in the order from the May 7th hearing, you made it clear that Mr. Zimmer was not relieved of his prior of the payment obligation. This is an additional obligation, but we had a hearing in September of 2025, and you entered an order that he was required to pay off the balance owed to my client, $65,516.20 in 4 installments. First one was due December 25th, and then every 90 days thereafter, and there have been no payments. Through today's date, there still have been no payments. If the court recalls, that was basically a follow-up to Mr. Zimmer was cited or found to be in contempt 2 years ago. I think it's 3 years ago now, because he hadn't been paying the ordered payments to my client. At the contempt hearing, you found Mr. Zimmer to be in contempt. You ordered as a purge that he make regular monthly payments until the obligation was paid off. And at that time, it was regular monthly payments of $1,000. When we had the hearing last year, we had filed a motion because he did not make regular payments. And that's basically at that point in time, the court accelerated the due point on that judgment because it's all past due. This was all from the 2018 divorce decree. At the May 7th hearing, basically the issue, and I may be providing more background than the court needs, but I think, because there's periods of time that pass between these hearings, sometimes this information gets lost. So I just want to make sure that it's recounted. We had filed a motion on February 27th to enforce because no payments were made, and no motion of any kind for Mr. Zimmer to get out of the payments, to reconsider, alleging that he had no ability to pay. So clearly that the judgment was not ever set aside or altered or amended. The hearing was on May 7th, and Mr. Zimmer did not appear for that hearing, did not provide any medical records. You did order, as you recall, Your Honor, or reading from your notes, that if he's alleging a medical reason, he's required to provide records to substantiate that. So what happened, we received, so May 7th was the court hearing. Today is August 10th. The court order had the list of documents attached as Exhibit A. And there were 6 categories of documents, actually more than 6 documents actual, but there was 6 different categories of documents. The order language basically said he was required to provide the full comprehensive response within 45 days of the filing of the order. So technically, the order was filed on May 21st, which would have made the 45 days date July 5th. He provided nothing by July 5th. So one more instance, a laundry list of violations of valid court orders here, Your Honor. He provided no records by January 5th. It was due to a conflict on my end that the hearing got continued from its last setting of July 7th to today. We did receive, at any rate, that order was violated when he didn't provide them within 45 days. At any rate, Mr. Kramer provided some records by email last Thursday. Friday evening, he sent me a request for a protective order for medical records, and I haven't had a chance to review that. So I haven't received any medical records, but the records that we received are not complete. There's missing information. And Judge, I should also note, I appreciate working with Mr. Kramer. I know he's doing the best he can with what he has to work with here. So my criticism isn't lodged at him, but I'm very displeased with the situation here and basically what's happening. So we received, and I've only really had a chance to do a cursory review. So he was supposed to provide, number one, completed current personal financial statement signed under oath. We received a handwritten personal financial statement that was signed within the past few months. So that's number one. Number two, complete copies of any personal financial statements he provided to any financial institution in the past 5 years. Nothing. Received nothing on that one. Item number three, copies of the operating agreement and bylaws for any company in which he owns an interest. Your Honor, we did receive a zip file with some operating agreements and bylaws. To be honest, I haven't had a chance to review those. We did receive some responsive records. And again, between Thursday and today, I haven't had a ability to go through those thoroughly. Item 4, copies of his K-1 and the tax returns for the past 3 years for any company in which he owns an interest. Your Honor, we received 2 years worth of K-1s. I'm not sure that they're, so 23 and 24. And I have not been able to verify that that's for every company. It's concerning to me that there's no 25 information because K-1s have been issued some time ago. You entered your order on May 7th. Whether or not corporate returns have been issued, the K-1s have all gone out some time ago for 2025 and then would have been completed. We received none of those. The 2024 K-1s for ZA Technologies specifically and for us Upstate Custom Products, the 2024 K-1 issued to Mr. Zimmer said that he received distributions in 2024 of $182,939. So that's for ZA Technologies. For Upstate Custom Products, he received distributions per the K-1 in the amount of $130,000. So I have no reason, there's nothing that we've received that indicates anything any different than what the last year's return was, which was our last year's that were shared, K-1s, which were for 2024. Item 5, we received nothing responsive to that number. It says copies of monthly statements for all bank and any other financial investment accounts for the past 24 months for any and all accounts in which he has an ownership interest. Received 0. Number 6, copies of his personal tax return for the past 3 years, including all schedules and supporting documents. Your Honor, we received a tax return, a 1040 for 2023. There's no 1040 for 2024 or 2025 or 2022 in the event that 2025 had not been filed. So for paragraph item 6, there's one return. Your Honor, and unfortunately, where we're at this point, I appreciate the court's patience and efforts that we're putting into this to try to get these funds. that have been due to my clients in 2018 collected. Each time we have a court hearing, it's very frustrating for my client. Frankly, it's frustrating for me. She incurs additional fees. We're still not there, unfortunately. And Your Honor, it really just seems to me that Mr. Zimmer does not have any respect for this court's orders, as far as the timing of providing responses, as far as paying any amounts. Obviously, he's earning income. He's in 2024 was a period of time he was under contempt, found to be in contempt. He certainly could have paid off the judgment with those distributions. Judge, again, it's frustration, but he is subject to your jurisdiction, Your Honor. The contempt has never been purged. Feels like now we're going potentially on a wild goose chase. I don't believe that there's any other alternative at this point in time, other than for me, on behalf of my client, to request jail time for Mr. Zimmer until this is taken seriously and he retires this judgment.
Do you believe that the court has that authority under the original contempt that was filed?
Judge, if there's any gray area, I'd be happy to refile and reserve Mr. Zimmer, because I believe that's what is necessary. I'm not trying to invite judicial error. So if I believe he has never purged himself of that contempt, whether or not the court retains jurisdiction to issue a further penalty beyond the monthly payments and award of attorney's fees, I don't want to misspeak. I believe the court does. But again, the last thing I want to do here is invite judicial error for this court. So, but I believe the only remedy that is going to make a difference at this point in time is a sentence of jail time, because he has thumbed his nose at this court's orders time and time again. So I don't really see any alternative at this point in time. And if the court, well, that's the request. I'd be more than happy on behalf of my client to reissue a contempt citation in contempt. I certainly have a litany of items to include within that affidavit and accusation of contempt. And we could come back at the court's or earliest date. And if the judgment isn't satisfied at that point in time, we would ask for a jail sentence, Your Honor.
All right. Thank you, Mr. Vendeska. Mr. Cranmer, your response?
Thank you, Your Honor. I don't know if I didn't get a cent, but I recall, and I don't have that part of my file with me, but the tax or bank statements for a couple of these corporations and Kurt personally for 2 years were submitted along with these other documents he's referring to. If I made a mistake, I'll have to go back on my computer and see what I sent or didn't send, but I thought we sent those. If not, I can get those over to him later today. With regard to the jail time request, Judge, the contempt matter was filed, I think 3 or 4 years ago now, and we had several order backs or reviews, and finally that thing was journalized and taken off the docket. So that's done. We're here today on a motion to enforce the judgment. And the court can't order jail time on a motion to enforce a judgment. And I continue to assert, Judge, that Miss Stevenson has a judgment. She can enforce that judgment under a number of ways, all allowed to her under our statutes. For example, she can garnish, she can issue executions on non-exempt property, so on and so forth. There's many options. There's nothing for the court to really quote unquote enforce. She has the judgment. She needs to go enforce her judgment. And that's what needs to happen with regard to that. With the contempt payments, Kurt's told me he cannot make them. He's not had the money. I'll be honest with you, I haven't studied the K-1s he's got. With regard to 2025, Kurt told me that none of the tax returns are filed. The K-1s are at the tax preparer with all those other tax documents. And I believe that the deadline for filing is October 15th, if that he's on extension. So if that being the case, the fact that those tax returns haven't been filed isn't necessarily any problem. I mean, he's complying with tax law there. I understand that the medical records, the request for a protective order. Obviously, I don't know how many divorced people that want their former spouses to have access to their medical records. He's willing to submit some to Mr. Vendeska, and I realize, and I'll fall on the sword for this, I was late getting the protective order sent over to him, as he mentioned. But I would think we could work out a protective order that will allow Mr. Vendeska access to the healthcare records, and Miss Stevenson have no access to those. Or we could submit them to the court for an in-camera only inspection by counsel, or the court. I don't think that's an unreasonable request, and I'll fall on the sword for that delay and get the protective order sent over to Mr. Vendeska. But we continue to, again, reemphasize that, if they want to enforce their judgment, they can enforce their judgment, but I don't think I follow a motion asking the court to take all these additional steps is appropriate. This is a money judgment. It's been reduced to numbers. Kurt has struggled paying that for quite a while. Right now he's got fighting cancer. He was just at the doctor, I believe, this morning, if I'm not mistaken. And he may have to go to some other doctor later today or later on in the week or whatever. But we definitely don't think there's any authority for the court under this motion to enforce judgment and further relief to assess jail time or even assess attorney's fees. Again, this is an execution on a judgment. That's up to her to collect her judgment. And we believe all these motions and things are outside the scope of anything that does with collection of judgments. Courts deal with collection of judgments all the time. And, we don't have motions for attorney's fees. We don't have debtor's jail. We don't have this. So if you can't pay it, then you can't pay it. If she thinks there's exempt property out there somewhere, she can go get it. But Kurt tells me that he just hasn't been in a position to pay it, isn't in a position to pay it, and he's undergoing chemotherapy unless they terminated that just recently because he's got other health concerns. He's got possible nerve damage and a whole laundry list of things that I could, send over to Mr. Vendeska once we get a protective order in place. But we just think that this motion needs to be dismissed because there's no authority for the court to impose jail sanctions, impose attorney's fees on something such as this. Attorney fees are supposed to be not punitive, but to encourage enforcement. He doesn't have money, not willfully not paying. He just can't pay. He said he can't pay. Fees are usually tied to bad faith or willful noncompliance. And if he doesn't have money, you don't just simply say you didn't pay the judgment, so you owe fees. That's not any showing that he has the ability to pay anything. There's no showing of any bad faith, in my opinion.
Well, Mr. Cranmer, the court certainly has the authority to order somebody who owes a judgment to provide financial information. The court made a very clear order with a definitive time frame in which to provide the financial information. How come that wasn't done?
Well, Kurt has these businesses that he has with other business parties, and he has less than a 50% interest in one or two of those. And if his partners aren't going to release the information or prohibit him from doing it. You put him in an impossible position again. They're not necessarily 100% owned by him. And specifically, if he doesn't own more than a 50% interest, I don't know how he can just disseminate information that his partners don't want disseminated. I think that's, that's what his partners tell him to do. Now, we did produce some. Again, I think I'll double check on those bank statements, but I think we had submitted those.
But what about personal tax returns for the past 3 years?
I think we submitted those for 2023 and 2024. And again, 2025, Kurt tells me is on extension and has not been filed yet. That's what he indicated to me. So we will disseminate 2025 or turn those over. I don't remember when the bank statements cut off. They may have been December of 25, but I can get Kurt to give me his personal ones for 2026 year to date, I'm sure. And we'll turn on the tax return once it's filed.
Well, the monthly bank statements and request 5 for personal bank and financial investment accounts, that he's not beholden to anybody else for his personal.
Again, I think we turned over personal bank statements for 2024 and 2025. I can't remember if we had any beyond December of 25, but we can get those, I'm pretty sure. But I'm almost positive we turned over 2 years of personal bank statements and personal tax returns.
All right. Counsel, I'm going to take a brief recess. I need to review some documents in the file, and then I'll come back here shortly. We're in brief recess. All right, we are back on the record, same appearances as before. What I was doing, I was going back to look at the order that was produced from the September. And that was a hearing that basically concluded the ongoing contempt issue, because the court had ordered that Mr. Zimmer make $1,000 a month payments in order to purge himself. At the time of at that hearing, he had made those payments, so he wasn't in contempt. So the court ordered basically a new payment schedule, or ordered the judgments, specified a time frame in which to have those paid. So based on that ruling, the court doesn't have any legal authority at this juncture to impose a jail sanction, though it very well is probably necessary at this time to get some sort of compliance. However, I don't think I've got the legal authority to do so. So any request for jail time would have to come at a later time after if the court makes a further finding of contempt, which is probably necessary, as the orders that I made at the last hearing have not been complied with. So at this juncture, I'm not going to enforce any jail time because I don't believe I have any legal authority to do so. That doesn't end the court's frustration that orders haven't been complied with for Mr. Zimmer. No payments are being made. So
Your Honor, and I don't mean to overtalk the court.
Go ahead.
I did. I did check. We do not have a 24 return. We have correspondence, a form that he submitted to his accountant, but there is no 2024 return, so it's only the 2023. And I have not received the financial information. And if Mr. Kramer has that and just didn't include it with the email that was sent on the 6th, then that should be resent. Judge, that it's my understanding under the statute that the court does have authority to award attorney's fees as justice and equity require. I mean, that's the language of the statute in these domestic matters.
And I have ordered those through the course of these hearings. So yes, I believe I do have that authority.
That's more of a responsive remark. I'm not questioning the validity of the court's prior orders, Your Honor, to be clear. There were timeframes. This isn't a traditional judgment. There were timeframes assigned to these that the respondent did not comply with. Judge, at this point in time, and the dilemma, frankly, we could file multiple contempts, but there's a cost attributed to my client each time we do that. And so the balancing act here is, well, we want to get this paid without her going further into the hole but something needs to happen. So at this point in time, Your Honor, I would request that we get a new court date. I don't feel personally that I have any other options other than to renew a contempt through the formal process. Mr. Kramer then, once that's filed, can let me know if he'll accept service or if I need to incur the cost to serve Mr. Zimmer. And then we'll ask that cost be attributed to Mr. Zimmer, but at any rate to have him personally served. Your Honor, I would also ask Mr. Kramer keeps talking about garnishment, et cetera, et cetera. This Mr. Zimmer is an owner of a LLC. So we can't just assume that he received distributions from. So a traditional garnishment would not capture those. It would have to be a charging order. So I don't know if Mr. Kramer is saying that he wouldn't object to the court entering a charging order that we could have registered then in the state of Florida and the state of South Carolina against these LLC interests of Mr. Zimmer. Basically, that would be the only way to capture distributions. The reason I haven't requested that in the past, again, it's additional cost for my client to get those registered in a foreign state, to then have them served on his corporate interests. And we need to get this finished and put to bed and get it paid. But other than potentially a charging order and renewing the contempt, I think I'm out of options, Your Honor.
All right, Mr. Cranmer, any further thoughts or argument?
No, Your Honor, other than, again, I think that Ms. Stevenson has a judgment and she's free to enforce the judgment as she can, allowable under Kansas statutes, statutory and case law.
Well, how can she do that if she doesn't have the financial information necessary to enforce the judgment that the court's ordered?
Well, sounds like I forgot to, or didn't include something in the attachment I sent over. So I'm going to check on everything we've got. And I may just resend everything again, everything I've got, just so hopefully we're not missing anything. We will turn over the 2005 tax returns once those are filed. She's got some tax returns that we did turn over, so that's a start at least. And we'll do that. But again, she has the authority to enforce her own judgment. That's the law gives her that. And we think she should do that. And we don't need to be coming back to court. She can enforce her judgment. And that continues to be our position. And I will, as soon as we get off, try to figure out what I did or didn't send to Mr. Vendeska. And again, I just may resend everything that we have just to try it again. And we'll send it with an itemized list of what it is we're including. So there will be no question of what we've said up to this point.
I am going to set this over. Mr. Zimmer, you need to provide these records that have been ordered. Angela, let's schedule about an hour 30 to 45 days out.
October 2nd at 9 o'clock will work with me.
Works for me as well.
All right, October 2nd at 9 o'clock. Regarding and we've lost Mr. Zimmer from the Zoom. We'll see, let's wait just a second to see if he gets back on. Well, Mr. Cranmer, please assure that he gets that court date, October 2nd at 9 o'clock. Regarding the protective order for medical records, that's for the courts to confirm that there is a medical issue that he's claiming. If that needs to be an in-camera review, then I think that's appropriate. Any objection from counsel regarding that?
That would be
Your Honor,
fine with me. I would think, Mr. Vendeska, I could work that out, but that would be fine with me for an in-camera inspection.
Well, I'd like to have the opportunity to review those. I'm not opposed in principle to a protective order. I just haven't had the opportunity to review that from Mr. Cranmer. And Your Honor, then if that's the case, if they're entered they're produced subject to a protective order, I anticipate you would then receive them as an exhibit prior to the upcoming hearing. But I'm not opposed in principle to restricting their release. But I do feel that I need the ability to review what's in those records personally and be able to speak to those. I'm not opposed to the court reviewing those either, Your Honor, but I'd like to have the opportunity myself.
Well,
Chris, I don't think I objected to you reviewing them. It was just having them disseminated it all anyway to your client.
if you could restrict it to Mr. Vendeska, that you review them without providing their contents to your client, I think that would probably be appropriate. If your thoughts on that.
Yeah, I'm not necessarily opposed to that, but I just need to review the order that Mr. Cranmer sent.
Okay, well, that would be acceptable to the court to do it in that manner.
Yes, sir.
Okay. I think, Mr. Vendeska, I can work that out, I hope.
And then all previous orders regarding timeline for payment and so forth are still in effect for Mr. Zimmer. That hasn't gone away, obviously. And then
Understood.
regarding the request for attorney's fees, I'll keep that open and take that up again on October 2nd.
Thank you, Your Honor.
All right, any other matters that need to be addressed today?
Not that I
Not on
can
the-
think of.
And I'll
Not on-
expect, if Mr. Zimmer's not able to comply with the court's orders regarding these records, there needs to be a detailed explanation as to why he's unable to.
Judge, if I may, is that October 2nd via Zoom?
Yes.
Okay.
All right, anything else, counsel?
No, Your Honor. Thank you for your time today.
All right.
I don't have anything else at this point, Your Honor. Thank you.
All right. Thank you, everyone. If there's nothing further, we'll be in recess. Have a good day.
Thank you.
Thank you.